Hello, everyone. This is another Federal Tax Update podcast. I'm Roger Harris, and as if you have listened to this before, you know I am normally joined by Annie Schwab. But what is it they say when there's somebody from the 6 o'clock news that's not there? They're on assignment. Well, Annie told me to say that, but she's really skiing. So it's spring break. So I'm going to rat her out. And as much as she wanted to be here, it wasn't more than taking advantage of the spring break and going skiing. But I am not alone today, because that would be cruel and unusual punishment if you guys have to listen to me by myself for 50, 60 minutes. We have some wonderful guests, and before I introduce them, I want to kind of tee up what we're going to talk about, because if you've been in this business long enough, you realize that, I think we all recognize that we have to get guidance from the IRS. We have to follow rules. We have to track legislation. But more and more, there's activity in our courts that impact us or create opportunities, or perhaps change something that maybe we didn't know changed. So we thought it would be interesting to bring two expert people in the legal side of our profession and talk about some recent court cases. And we'll talk just generally about, when to bring people like our guest here, and just talk about our whole tax system from a little different perspective, as we are recording this on what is the first deadline. It's March 15th, which is actually the 16th. It's a Sunday, but so hopefully when you hear this, you have made that deadline and heading home for the final one. But let me introduce our guest today. We have, again, Jessica Marine and Peter Haukebo. And they're both from the Frost Law Firm. And a lot of you have heard the Frost Law Firm. I think you guys have, and not you two personally, but your firm has been present at some IRS forums, and we get a lot of writing from them. But first of all, let me welcome both of you, Jessica and Peter, and we're happy to have you here with us. I'm going to let you introduce each of yourself, because I won't do justice to your background and why you're here, and then we'll dive into some topics. But Peter, why don't you welcome? First of all, Peter, glad to have you. Why don't you talk a little bit about your background and maybe tell those that aren't familiar with the Frost Law Firm a little bit about the firm?
Sure. So the firm itself is deeply rooted in tax controversy. That's where we all got our start. Tax controversy, of course, is sort of any dispute with the IRS, and there's a whole cycle to it. So from examination all the way through to making sure that we can help folks with collection alternatives, and we do both white collar and criminal work as well. My background in getting into tax itself was through a low-income taxpayer clinic. I taught at the University of Maryland for 5 or 6 years, but have focused my practice almost exclusively in tax over the years. I'm a former chair of the Maryland State Bar Association's tax section, and recently have been doing a lot of the pandemic relief stuff from PPP and ERC and EIDL and all this sort of alphabet soup of stuff that's out there. And our firm has focused a lot of that and a lot of its resources on that kind of work as well recently.
Yeah. And you're located in Annapolis, Maryland. And our other guest, Jessica Marine, who I'll ask to introduce herself, is on the beautiful coast of Florida, where I'm sure the weather is beautiful today, a lot better than it is here, and going to be in Annapolis. But Jessica, welcome. Talk a little bit about your background.
Thanks for having me. I am in Florida, but I am a Maryland native, just a recent transplant to sunny, warm Florida. But so I too started at a low income taxpayer clinic when I was in law school and fell in love with tax controversy. I didn't even know it was a profession that existed. Yeah. So that was a shock to me. I've now spent about 2 decades representing taxpayers in a variety of ways against the IRS and taxing state taxing authorities. During my career, I also spent a significant number of years at the U.S. Tax Court. So I have some government experience. In my role at the U.S. Tax Court, I started as a law clerk for a judge and went up the ranks. And my most recent role there, I was a deputy clerk of the U.S. Tax Court. So I've seen a lot at the court. Yeah. See how the IRS approaches things when it gets to court. And I was very happy to help lead the court's response to the COVID pandemic and moving our workers off site, figuring out how to do remote proceedings so that taxpayers still had access to the court. And I also helped build the court's new case management system. So I have a little bit of IT background as well under my belt now, but I've boomeranged during my career between private practice and working for the government. And so now I'm in another phase of private practice where I'm representing, I like to say, real people with real problems and helping them navigate their issues with the IRS, making sure that they're well represented, especially in this day and age when the IRS is underfunded, understaffed. It's really, really hard for someone to navigate the IRS without help. And so that's where our firm comes in.
Yeah, and that's probably always been true, but it's just gotten worse. That figuring out how to navigate the IRS or get to the right person and get the right answer or get an answer that you can trust has been difficult. It's funny when we hear controversy. I think a lot of people who think if they know how to prepare taxes are skilled to handle any controversy that may come up. But it's really a different world than just preparing a tax return. The rules and the way you operate. Just because you know how to prepare a tax return doesn't mean that you know how to properly represent someone, at different stages. Now we can all handle a lot of the basic stuff, respond to notices, an audit, but it can become a lot more challenging and a lot more difficult. And that's where people like you guys come in. One of the things that drove us to having this podcast today, and I'll ask Peter to comment on it, was a case called, I think I've got it correct, Kwong, which again, I'm betting that most of the people with their heads down doing tax returns right now have no idea what the Kwong case was, what it means, what it did, but it's going to revert back to some of the things during the pandemic and create probably some opportunities for us and our clients, or you representing our clients, because again, I'm not sure if this is something that the average person who prepares taxes would want to get into. But Peter, talk a little bit about the case and what it does and what it says, and then we'll kind of dig deeper in it. And Jessica, you comment obviously whenever it's appropriate here. This is a democratic podcast. Everybody can speak when they want to speak. There's no order here. But Peter, why don't you kick us off?
Just real high level, the Kwong case came out, or the decision came out late November of last year. It was in the Court of Federal Claims, and it addresses, again, like 10,000 foot view, what to think about certain deadlines and events within the IRS that happened or didn't happen during the pandemic. And the case, by and large, and I think Jessica should jump in here a little bit, it is it's affecting the way people are looking at what happened basically between January 20th, 2020 and May 10th of 2023. And it's just applying in a very textual way code that Congress wrote. And it's having some very interesting repercussions now that this opinion has come out.
So let me see, from a layman's term, it had to do with some deadlines, if I'm correct, where I'm going to butcher this because I'm certainly not an attorney. The way the IRS read it and determined deadlines to charge penalty and interest versus, I guess it's the intent of the law, and that's what you went to court to kind of get it cleared up. Am I getting close, Jessica?
Yeah, I can hop in.
Jump in and help me, save me here.
It really is. It's about deadlines and how tax deadlines intersect with federally declared disasters. So COVID was a long-lasting federally declared disaster. There's a code section in the Internal Revenue Code. It's 7508 capital A. And it basically says that all deadlines are postponed during a federally declared disaster. And that's really high level. And so the IRS tried to cap it and say, yeah, but only for a year. And so what the Kwong court came through and said is, no, IRS, you can't artificially cap it. So as a result, because the COVID pandemic officially lasted from January 20th, 2020 until May 10th, 2023, that's when President Biden came and officially declared the pandemic over. the statute then tacks on an additional 60 days. So that got us to July 10th, 2023. So basically all tax due dates and all tax payment due dates that fell during that 3.5-year period were artificially moved forward. And now they were all due on July 11th, 2023. And so as a practical matter, all tax returns for tax year 19, 20, 21, and 22, they weren't due on their natural due dates of April the following year. They were all pushed to July 11th, 2023. Well, the IRS accrued or assessed taxes,
Sure.
penalties, interest, right, on their normal
Due
cadence.
dates. Right.
And so as a result, a lot of people got overcharged interest and penalties if they were late with those tax returns. And so what Kwong is allowing us to do is go back and recapture those overpayments for the taxpayers. Now, I need to be very clear. This isn't going to happen automatically. You have to file a Form 843. It's the claim for abatement or refund.
Right.
And it has to be done in a certain time. And the window is very short here. So it's expiring there might be some exceptions, let me be very clear, but by and large, July 10th, 2026. So just 4 months from now, a little under 4 months, is the deadline to file those claims. So if you or a client have paid or accrued interest and penalties for those tax years during that period, you really should consider going back and filing a claim to try to get this money back for your clients.
Now, and I'm going to answer this question. Whoever wants to answer it, feel free to. Does this just apply to individuals? Does it just apply to income tax? Could it apply to payroll taxes, corporations, or is it,
We think it applies to everything.
Okay.
There's a specific code section that talks about the various things that it applies to, but it definitely applies to income tax. It definitely applies to employment taxes. It more than likely applies to corporate because that's also an income tax. And right now, because the IRS hasn't issued any guidance on this, I think you should think broad and file the claim and then sort it out later. What you don't want to do is wait and see, right? Because if you miss this window, you're not going to get it later.
It doesn't matter. And I guess the IRS is not in a hurry to issue guidance on this, given that there's a deadline.
In the Kwong case was a further extension of this idea that had already begun within the tax court. So there was a prior case called Abdo, and I think 2 or 3 cases that came after that are just slowly building on this concept. And so when you ask, what is this available to? It's not entirely clear. I mean, as Jessica mentioned, sure, there is an enumerated list, and generally we understand how that list is supposed to work, but trying to figure out every possible eventuality, like Jessica said, I mean, I think this is the opportunity to dig in with your clients and evaluate whether or not something may apply to interest, to penalties, to the tax itself. It's leading to interesting results.
Yeah. So if you've had anybody in that time frame get penalties and interest for late filing, this is a good thing to look at before July of this year to see. And did the IRS, I mean, I guess the court, this was the IRS against somebody else, whoever, Kwong, I guess, who brought the case. Did the IRS just say, okay, you're right? Or is there any pushback now? Or I think there was an article in USA Today, I think, Jessica, you were quoted in it, where they appear to be recognizing it, but have they come out and said, yeah, this is new? But I guess that would be guidance that we haven't seen yet.
Well, I think, so Kwong is interesting because it was a motion for summary judgment filed by Kwong's attorney, and the court issued their ruling, which we're all relying on. The government has not appealed that ruling. They could have filed an interlocutory appeal, which means while the case is still pending, they didn't do that. And the case has not come to a natural conclusion yet with a decision where then the automatic clock for filing an appeal would start. The parties are negotiating settlement right now. So everyone expects the government to appeal, but they have not done so yet. But there was actually a very interesting development on Friday. I, as many tax practitioners in this area, have been arguing Kwong whenever and wherever we can for our
Before the
clients.
ruling, that one you still took the position, right?
Of course. And so I had a case that was in tax court. It was a deficiency case where the IRS said my client hadn't reported some income on his tax return. And so he would be normally subject to failure to pay penalties and interest on that deficiency. And I brought up Kwong when the case with the IRS Office of Appeals, and they actually stipulated in a decision document that was just filed in the U.S. tax court this past Friday that he wasn't subject to penalties or interest for that period. And so I don't know if this is a one-off or if it's a signal of the IRS starting to acquiesce to the Kwong opinion. They have not issued any formal guidance on this. I'll be honest, I've sort of turned into a minor celebrity over the weekend because of that decision document.
Be careful.
I know. I'm getting lots of calls from people. And what I'm telling them without fail is you should continue to push this issue. You should file the claims for your clients. And I don't expect us to have clarity in the near future on this. So despite that decision hitting the tax court on Friday, I don't necessarily know the IRS is going to release something today saying, we agree.
No.
My gut tells me they're just laying low on this issue because the window is only till July. And, after July, their exposure is limited. And so what I believe is happening is that they're not going to automatically issue refunds. They're only going to issue refunds to people who submit the form and claim them. And they're not going to take a position in the interim to just wait and see how many claims come in, right? If they issued guidance today and said, we're acquiescing to this, they would get flooded with requests, right?
Yeah.
So I think it's in their interest to just stay silent on the issue and react to the claims that are filed. But
Roger, that was a shocking result. Like truly, in Jessica's case, it's amazing. It's awesome. It's why you get tax attorneys involved to advocate and to pick these things apart and to really dig in. But that was an incredible result in that case.
Yeah, I think the one thing we have to realize, sometimes it takes someone with deep pockets to go that far to get a ruling like that, but it can impact people at a much smaller level that individually would have never had the wherewithal financially to push something all the way this far. But now that it's out there, I bet everybody can look back in their customer list and find somebody that has paid penalties and interest, that now they can get refund. Is there any magic to the 843? Do you just say, I need this money because of Kwong? I mean, is there anything that we need to know to file the form other than that this is available and it's out there?
Yeah, I think you have to be very specific in the grounds and facts for your case. And that's just the idea that if the IRS doesn't process these things administratively, you're going to have to go to court. And if you go to court because the numbers are significant enough, the judge is going to want to make sure and can analyze this independently because they have to make sure that they're able to even hear the case. And there's something called the variance doctrine. And if you haven't taken the opportunity to really put before the IRS a claim and stating all of the grounds and all of the facts that make you entitled to it, then you can't show up at court and surprise the government. So yeah, being careful about what you put in these things is going to be really important.
So if it's a large sum of money, this again, going back to my earlier comment that just because you know how to prepare a tax return and you may have prepared an 843 before, doesn't mean that this is something that you should try to do. If there's a lot of money involved, call one of these two folks or the Frost firm in general and get some professional help, because if you're going to if you're going to try to get this money, you should do it the right way. And I'm guessing if you don't make the deadline or all right, I promise not to throw a curveball, but let me ask you this curveball question because I knew I wouldn't get by it. If you are aware of this and you have a client, let's just say they got $1 million in penalties and interest that they could get back if they knew what to do, and you didn't inform them of it, do you think there would be any liability on the person who was aware of it, I'll talk about a tax preparer here, and didn't bring it to the attention of their client, do you think the client would have any recourse for not at least being told about it? Or is this just kind of, it is what it is? You either know or you don't know.
Well, I don't think it's fully settled law at this point. I think that this is an opportunity for return preparers, accountants, CPAs, financial professionals to be the hero, and to sort of come in and say, "Hey, have you heard about this thing? Let's go through and see what you got going on." As far as exposure, I mean, I think the question always sort of comes back to what were you engaged for?
Right.
You were engaged to prepare a return. That's not necessarily advising on subsequent legal action that may affect that. But this is really an opportunity to go back through and think through, I had filed that balance due return for 2020. I bet they paid a bunch of penalties and interest related to that, but actually it wasn't due until 2023. So it's sort of that opportunity, I think, to come in now.
Yeah. So once you finish April 15th, take a few days off, do whatever you do after the 15th, go look through. I think we all wanted to forget about COVID and the pandemic, and we're going to talk about another topic related to that in a minute. And look and see, because I'm sure we all have clients that, because of just the way the world we were in, filed late, didn't have the records, filed late, maybe got huge penalties and interest. We didn't know any better and told them to pay it, or they just paid it automatically. And this may be a chance to get it back. So it's interesting. What else? Is there anything else other that you would tell a practitioner or CPA or financial, whoever it is, to do other than just look back and identify the people who paid penalties and interest for late filing and get on this? Is there any other little thing that they need to be aware of or look for other than just the general high level penalty and interest reason?
I mean, Jessica, I don't know your thoughts, but I think it goes beyond just penalties and interest related to an income tax module. You may want to have a CivPen module to look at ACA compliance, fair to file, fair to furnish issues, those types of things as well. The enumerated
applies to all of that, not just
all of it.
Yeah.
I think the other thing, I know maybe I narrowed it right to 2019 to 22, but there's certainly, I've been talking to a lot of people over the weekend, and people are really taking aggressive positions here. And because it's not settled law yet, they're like, what about an older year? Let's say you filed a tax return for 2017 and didn't pay it, and it was still unpaid during this period. So you were accruing interest and penalties. And so there are, and I think we're starting to move into that space as well, that we're going to file, we're calling them protective refund claims,
right,
for our clients who fall into that category. So I think practitioners should be looking just globally. Did you have clients that owed money during this time? Not necessarily limited to tax years 19 through 22. Like 19 through 22, clearly the filing dates, that's a specific
that's pretty
issue
straightforward.
for them.
Yeah.
But accrual of interest and penalties is maybe a broader issue here. We're doing it, right? We're looking through our clients that we have, both current and former, and seeing what opportunities there are. And we plan to, and we've started reaching out to them and explaining what's going on. This is your potential savings. Would you like to proceed with filing some sort of claim? I think a lot of the tax practitioners I've talked to in this space are doing this work on a contingency basis. Because as Peter said, it's sort of free money, right? You get to be the hero in this story. And if you can get money back for your client, right, maybe you get a percentage of that. So there's no risk to the client in doing that sort of engagement, but there is a huge upside to everyone.
So let's wrap up this and move to another topic, but it's look through for any reason that there was any of these penalties and interest accrued or paid during this time frame. Take a shot, send it in. We don't know where it's going to finally land, and feel pretty good about returns in that time frame. We just don't know about anything else that might happen there. So go for the big one and see where
Correct.
it's up.
And one last practice point before we move on. the 843 is one of those weird returns that or forms that still requires an original signature. So don't have that little foot fault and take an electronic signature on it and send it in. So if you're preparing the 843, make sure you and your client both have original signatures.
Yeah, good tip, because that'll just be that little technicality that kicks you out.
Yep.
All right. It seems like almost every podcast we've done, we talked about employee retention credit and something about it. And I think a lot of us now have kind of put it behind us and not thinking about it. Though I know we all have people who still wonder if their claim's ever going to be paid. Did they get paid the right amount? Was it rejected properly? Peter, I know, in fact, I got something today. You're doing a webinar tomorrow on St. Patrick's Day about some ERC issues, and I know you've written some articles. What is something that, for those of us that kind of put it behind us once we thought we got everybody paid, or we're told that after this date there's nothing else, it's over? What are we missing? I know there's stuff about ERC that perhaps we need to think about for some of our clients.
Yeah, and I guess just to pull us back a little bit to the topic we were trying to move on from in so many ways, both ERC and from Kwong, because what Jessica said was interesting was to remind your listeners to think through, people who may have owed tax during those periods. It's even worse than that and harder than that, because they may not have known they owed tax until outside of that period. And you're seeing that with ERC. So imagine a scenario where someone in ERC received refund checks prior to this July 11th date, to the extent they were then later audited and that credit was reversed and now a balance is owed. The government's going to try to run interest from the day that refund claim was initially paid, and query whether this is a scenario where that's appropriate or not. I would argue that it's not, according to the same analysis for Kwong. So if you're in a situation where you are having that refund clawed back in that you paid it, you're probably owed some additional interest, and that's certainly something that we're looking at very closely, because it could affect quite a few taxpayers. As you know, the government made quite a fuss about ERC and inappropriate claims and enforcement and all that kind of stuff. So that's sort of the intersection with the Kwong.
So if you gave some money back voluntarily or through an audit, I guess either way, and they charge you penalties and interest, this Kwong case could open up the door to get those penalties and interest back as well.
Yeah, I think the voluntary disclosure program was done without interest or penalties applied.
Right, that's right. That's right.
So there's certainly some exceptions as far as giving the money back, but yeah, if you were later assessed, and interesting question about whether or not that assessment was appropriate given some of the rules as well, and I think that's going to be an interesting place for challenges. But if you did pay it back and were assessed interest, you probably have a right to get that back.
I think I'm correct in this, but for people who had a claim denied or told, can you reopen that? If you really thought you were entitled and didn't get your money or had to give it back, have you guys been in that arena and found some success in going back and telling the IRS you got it wrong?
God bless your listeners who have been able to get out of ERC. We are still very much in it and doing the audits and doing the protests and doing the responses to the IDRs. It's not been in a situation where I've had to reopen anything. These things just have not closed.
So they were still open.
They're still open. I think the recourse for many of them would be court action. We're seeing a lot more post-appeals mediation opportunities. So even though alternative dispute resolution has been around at the IRS since the late 90s, it's not been pushed in a big way. It's our understanding that the Office of Appeals is pushing these post-appeal mediation opportunities. So it's sort of like a half step before you're getting into litigation and trying to resolve some of the disputes. So these are very much ongoing. We have hundreds of these cases that we're still working through.
And one of the things that we're starting to see, unfortunately, is that the IRS is just issuing blanket denials. And so it's forcing taxpayers to move forward with filing the protest and going to appeals and doing the mediation that Peter's talking about. And it's unfortunate because that's not what should be happening here. And in fact, we had a call with a taxpayer advocate this morning who was sort of expressing their displeasure at the IRS's handling of this, and it's clogging appeals up. Appeals, I think, has almost a 6-month backlog now to even have a case heard, which, appeals was intended to be a quick resolution
Right.
path. And it's just because so many claims were filed, they're just routinely denying them, forcing everyone through the appeals channel. And I think what's most important there is just make sure that you're meeting deadlines. These are very strict deadlines. You need to file your protest on time. You need to keep an eye on your the claim for the date the claim was denied, so you know exactly how long you have. You have the 2 years to file a lawsuit if you want to go the lawsuit route. But if your case gets stuck in appeals for 6, 9, 12 months, right, that's eating that time up. So
Right.
unfortunately, as Peter said, we are a long way from done or moving on from ERC claims.
Yeah. Yeah. I think, I know the IRS is sick of ERC and just wants it to go away.
Well,
I
then
think
they
a
should
lot.
grant them all. Like they
Yeah,
did
just
the
go ahead and pay them.
opposite of
Just
what
pay
they
them and
should do.
they'll all
Yeah.
go away. Well, some of them, but yeah, I mean, the whole thing was, and again, if you've listened to this podcast, you know that Annie and I have thought that it was well intended. We got to think back and remember we were in a pandemic. None of us knew if we were going to survive the pandemic or businesses were going to survive, and Congress acted quickly. But gosh, there were some things that could have been done that would have made this such a better program from the beginning. And I have to say that the IRS was told about some of the things, but some of it's Congress's fault. But this thing may never die. I mean, I don't know that we're ever going to put it to bed. So if you still think if you're in the middle of one of these battles, this is something that you guys are. I think I want to say that's the first thing I heard of Frost was through ERC. I mean, is that just me, or is that kind of where your
No,
firm?
I think it really elevated us to more of a national brand or firm, and we're soup to nuts on the ERC stuff. So it's still
Right.
audits and appeals, but also litigation against the government. A big issue that a lot of these folks are still getting jammed up with is their relationship with their PEOs, CPEOs,
Right.
other third-party payers. So we're really trying to hold those folks accountable. Again, Congress didn't make it easy on anybody. I agree with you. But some of these third parties are making it worse for themselves, for everybody. And so that's another area that we've been working pretty extensively in.
Peter, you mentioned PEOs. If our audience isn't familiar what that issue is, talk just high level. What is the issue with PEOs if that's where you went to get your ERC?
Right. So the IRS has been consistent in their posture that the relationship for them, as far as who is the taxpayer, is going to be the PEO. So
Right.
a PEO files an aggregate return, Schedule Rs, and you could have tens or hundreds of schedules attached to a 941. Right. So all of that credit work is running through the PEO. And if you did anything with ERC, you know that there's just very little information that's reported about anything.
Right.
And then
just a number. Just give me this much.
Yeah. Yeah. I mean, they're not even capturing NAICS codes, right, on Schedule R. So it just makes it really hard to analyze anything.
So for that reason, you're kind of hung up if you're one of those 100 people on that 1941 and you're at the mercy of the PEO.
Potentially, but what's happening is the PEOs are not communicating, not sharing status, right? A taxpayer client, customer of a PEO can't go to the IRS and figure out if they've been paid. And you're seeing situations where PEOs, third-party payers, have received the refunds and sat on them, generating a ton of interest, depriving taxpayers of the use of those funds, frustrating the will of Congress and what it was trying to accomplish through these programs. And so it's those situations. But sometimes it's even worse, where a PEO could have a balance due to the IRS, and the IRS has said, we believe we can offset that.
Yeah, we're going to offset it. Yeah.
And, so that has generated some major issues as well.
So you could be having an issue with the PEO or the IRS or both.
Correct.
Yeah. Well, there you go. That's a nice, simple little solution. Anything else we need to think about on ERC? I mean, is this kind of where we are? This is the last remaining place where we're dealing with ERC, is the kinds of cases you're talking about. Is there anything else still lingering out there? I mean, I know they said they've processed all the forms the IRS has. I don't know if I believe that, because all I hear is, well, I never got an answer on mine. But are we over with this, or down to one or two lingering? Not that they're going to be quick and easy to solve, but where do you think we are in that program at this point?
Well, there's a couple hundred cases that are in the federal court system now, and you're starting to get opinions coming out. So how that sort of impacts the thousands, tens of thousands, 80-something thousand claims were disallowed and are potentially working their way through appeals. Yeah, I think they've said all but 20, 30,000 have been processed, but those are likely to end up in exam or review of some sort before they get pushed out. So there's still a lot going on, and some pretty consequential issues that are up for summary judgment consideration before courts. There's a bankruptcy decision that I think most of us in the practitioner community thought was not well reasoned, but that's on appeal, and so it's going to just continue to go until these cases work themselves out.
So it could be like Kwong. We could get a court case that opens up a whole new place for us to go that maybe we didn't consider. So it's not over. And you may not know this, but one thing I know a lot of people in our community are interested in: how much effort or success is the IRS having going against some of these, what we call ERC mills, that created a lot of the problems? Is this is particularly given the IRS's lack of resources, people, money, that's this. Are the bad guys just going to get away with it, or is there really any real effort?
There was an indictment last week on a $52 million tax loss. I think that there's still quite a bit of activity going on in the criminal space, that you'll start to see more and more of these play out. I think that stuff is probably still happening. By and large, criminal enforcement has gone down.
Sure.
But hopefully the mills, the true bad guys here, the truly fraudulent and fake stuff, they're held accountable.
Yeah. Again, general question to the two of you. I know the people in the preparation field, they have they're feeling some of the impacts of the IRS budget cuts and people cuts and layoffs and all that. Are you guys seeing the same thing in where you're interacting with them? I'm assuming this is agency wide, but are you guys having some of the same problems? I mean, ours is more a little basic. Nobody answers the phone. If they do, they don't know what they're saying when they do sometimes. So, but are you guys having the same struggles from your point of view dealing with the IRS?
100%. I think it's everything. The IRS is already hard to navigate. Right. And now it's even harder to get someone on the phone, or get someone on the phone who's willing to help you, who is not stressed out, overworked, if they even answer the phone. Right. I'm finding myself filing more and more taxpayer advocate requests, which I don't love, because now I'm clogging that pipeline.
And they're getting overwhelmed.
Exactly. I will say they have changed their way of assigning cases, which I've been very pleased with. It used to be that you would send a taxpayer advocate request into the local office based on the taxpayer's location. And so if you have, I don't know, a busy area, you have a lot of work, but a less busy area didn't. So they've changed that. And now everything goes through a centralized point, and it gets pushed out based on capacity. So I am finding that case advocates are being assigned to the cases faster than before. They're not necessarily in a location similar to the taxpayer anymore, but right. I don't think you need that.
No, that's one thing we did learn through COVID is we don't have to be in the same office to get things done.
That is true. Hence me in Florida.
That's right.
But no, I try to explain to folks, and it's very frustrating for our clients where it should be. And I say to them, under the normal circumstances, this would be a very simple issue to resolve. However, nothing is normal anymore, or maybe this is our new normal.
Mhm.
I have I'll give you a real brief example. I have a client where she purchased a property from a non-U.S. citizen. She did the proper withholding, remitted it, and somehow the IRS did not attribute that payment in to her social, and she's been getting notices for 6 years, basically saying, "Where's our money?" And we're sending them a copy of the document that was sent, a copy of the canceled check that the IRS negotiated, that has the IRS tracking information on it, and we still can't get them to just acknowledge and apply the payment and stop the notices. So everything is so much harder, longer. People say, "How long will something take?" I give them like my best guess, but anymore, I multiply it by 3 at least to try to manage expectations.
Yeah, I mean, I feel bad because I think there's a lot of really hardworking people at the IRS, and the taxpayer advocate for, many part of my career was the one place you knew if you went to, you could get something done and get it done quickly. But they're just being overwhelmed because everybody wants to go there now.
One thing that I always try to do when I get someone on the phone, I try to be empathetic because I know that
Oh yeah,
almost everyone that is calling is angry, and it's no use. And I feel my grandmother used to say, "What's that? That you catch more flies with honey," or whatever that saying is.
right.
I've always taken
Than
that.
vinegar, yeah, more than
Yeah.
honey than vinegar, yeah.
So I've always taken that to heart in my career, and it costs nothing to be kind. So when I'm calling the IRS or dealing with people at the IRS, I know they're stressed, I know they're overworked, and so I try to be empathetic. I try to, not play into that, but like you get more when you have that type of dynamic. I don't yell or curse at people at the IRS. They're just trying to do their job, and we're trying to do our job.
Yeah, I mean, that's just a good thing in life. I'm always amazed when I'm at the airport and somebody's yelling at the gate agent because the plane's got a problem. Well, they can't go fix it. We should all try to put ourselves in those people's position and understand that I think they want to do their job and they want to, get it done. Most of them do. Some maybe don't care, but most of them do. And it doesn't take much for us to be nice and try to get them to cooperate, uh, and be empathetic, as you said, but we've got people who just think yelling makes it better. I guess they think everybody they deal with is deaf, so if they just yell louder, they'll hear them. So you're experiencing the same thing. Well, that didn't make me feel any better. I was looking for somewhere that we could go. I don't think this topic probably directly impacts a lot of our clients, but it gets a lot of publicity. The whole idea of tariffs. The Supreme Court ruled that the authority that the administration was using to charge tariffs was the wrong one, or I don't know. You're the lawyer, so correct my stupid remarks I'll make here. And then immediately after that, we got into this whole discussion about refunds. So if you can't charge a tariff, and you did, and I paid it directly or indirectly, I know FedEx came out almost immediately after the Supreme Court and filed something to get all their money back and said they would give it to their customers. I mean, is that, I don't know. I mean, I don't even know what I'm asking other than when people say, "How do I get my tariff refund?" I go, "Well, there's no form for it yet, so don't worry about it." What is this ever going to get solved, or are they just going to say, "Well, from now on you can't do it," or do you think there'll be refunds? And if so, what in the world are we going to have to do to get that money back, if ever?
Well, it's interesting because after the Supreme Court struck down these particular tariffs, the president added some additional ones. So these in particular were related to the International Emergency Economic Powers Act. So there are situations where Congress has ceded some authority to the president. The Supreme Court, the Federal Circuit, the Court of International Trade all disagreed that this is one of those circumstances. So the levies that the tariffs that he put in place related to this particular act were deemed invalid. And so you had a case called Learning Resources that was paired with another case called Voss Selections. Those two cases came up through different courts, actually, but the Supreme Court dug in and said, no, you can't do this, and sent the case back down to figure out what the heck they are going to do. And the way that the process with customs works is a liquidation situation. Imports are either liquidated or not, and the timing of which was starting to press up against the idea that these would be liquidated, and folks were starting to file a whole lot more lawsuits in the Court of International Trade. I think you've had 2,000 or 3,000 in the last 30, 45 days, something like that. And so it's a major issue where these, in the first instance, the importers of record are coming back like FedEx and saying, time to send me a refund.
Yeah. And, again, I guess I've paid tariffs, but it was never been something where I looked at an invoice and said tariff $10. So I'd have no idea how much I'm paying in tariffs, but I guess if they're going to pay everybody, let me get in line too.
Well, FedEx, you might, right? They were sort of saying, look, if you want this, we've paid it for you, but you've got to turn around and pay this tariff. And so that's a particularly interesting case because they've already sort of come out and said, we will make these refunds available to the actual payors, acknowledging that, they didn't actually foot the bill.
Yeah.
But there's a lot of companies, right, where they paid tariffs and just passed that along. They increased the price of their goods and passed it on to their clientele. It is unlikely that the people who bought, the end user or the end buyer of that, is unlikely to see any money coming to them. Now, we might over time see prices start to come back down as tariffs are removed. But I think one thing I will say is, unlike Kwong, where I think a tax preparer could potentially navigate figuring out the amount to put on an 843 and filling it out, I do not think tariffs are necessarily somewhere where a tax preparer should feel comfortable navigating that space. There's a lot of nuanced timing rules with the customs enforcement, the Court of International Trade. So I do think that if you have a client who has been charged tariffs, either as the importer of record or as the secondary purchaser from that importer of record, you really should be recommending to them that they seek legal counsel on how to timely file these refund claims.
Yeah. And that is a perfect segue to how I wanted to kind of wrap up our time together. Talk a little bit, talk to the people. I mean, I'm speculating here. We don't have a perfect list of who our listeners are, but my assumption is they're primarily tax firms preparing taxes. I'm sure there's some small ones of 100,000 up to, millions of dollars. And then I'll let you put a plug in for Frost. When is it the right time to contact someone like you? Is it based on and maybe it's all of the above. Is it based on the facts? Is it based on the cost? Is it based on knowledge? It could be all of these. But if you were talking to them of when they should call you, and then let's make sure you tell everybody how to contact Frost, because I know you're not just in Annapolis or Florida. I mean, you're pretty much all over the place. But how would someone make the judgment, and when is it appropriate? And can you just pick up the phone and call and say, I think I got a case, or I think I got something, or you need to be specific and having more information? So educate our listeners to when you guys can particularly be of help to them. So and I'll let you decide which order to go in.
No, I mean, my answer is early and often, but not every touch point has to become a case, right? Like at the end of the day, I want to see people do it right. I want to see taxpayers get the right service and the right answer. And if that means I jump on a call for 5 or 10 minutes to walk you through something or talk you through an issue, great. That doesn't need to result in any fees or representation or anything like that. Right. Beyond that, it's a question, I think, of what value are you adding to the case for your taxpayer and what's your comfort level. And it's going to be a different answer for everybody. I think the first point you have any concerns about something going criminal, you
Right.
run to your nearest tax attorney as fast
Exactly.
as you possibly can.
Yeah.
But, if you're going through the rounds on an audit and it's a sticky situation, like, keep at it. If there's something you want to talk through, the one thing that I'm reminded of in the opening conversation here is tax controversy attorneys are a little bit different, and it is a little bit different than filing a tax return. And it's because of the language that we speak. We're speaking a procedural language and understanding the ins and outs of dealing with a bureaucracy, the most powerful creditor in the world, like, those types of situations. And we know how to communicate what we need to communicate through a financial or through whatever it is that's a little bit different than just, a tax return.
Yeah. You're, again, I'm going to oversimplify this. You're the expert in the process and how to make that process work. And I think that's important. That's something there. Jessica, anything else that you would add to that, or how do they get in touch with you guys, or how does it work?
Sure. Yeah, I think Peter's absolutely right. I think your comfort level really plays a lot into this, right? We're not all experts at everything. We have strengths and weakness. I'm not a return preparer. I wouldn't prepare a return, right? So perhaps a return preparer shouldn't take someone through an audit if they're not comfortable in that space or litigation, et cetera. And the other thing that I'll add, what Peter said, sometimes he hops on a 5-minute call. I do too. We generally do free consults to clients. We also do paid consults, right? So if it's just a narrow issue, we can do a 1 hour, half an hour paid consult, or we can do a full engagement. So it's not a one size fits all. We really try to diagnose what the issue is, how we can help, and what our involvement looks like. And we have lots of CPAs, return preparers, who refer work to us all the time. To get in touch with us, you can go to askfrost.com, and there's ways to schedule consults. Our phone number's on there. I'll just shout it out for everyone. It's 410-497-5947. But we basically, if we can't handle your issue, we normally can provide a referral out. So that's the other thing that I think we add value. Yeah. We have a strong network of referral partners. And so some things aren't a good fit for us, and we're quick to help people point in the right direction for that.
Great. Thank you. Guys, this has been great. This is something that we need to have you guys back, or you need to make sure that if there's another Kwong or something out there that we need to know about, please let us know, because I think that, again, it's just not an area where we probably pay as much attention. We kind of rely on somebody telling us about it. It's not something we look for every day, and yet there probably is opportunities that we're not seeing. So again, I want to thank both of you for doing this. This was great. I know you guys are busy. You found some time to do this, and I really appreciate that. And again, I'm serious. Let's have you back, and as you see things, and hopefully one day we can run at each other face to face and talk more about our business.
One thing I will highlight for your listeners is they might start seeing SBA EDIL loans. That's a new hot topic that's really coming up, that folks who took the economic disaster, income loan?
Economic impact disaster loan.
Yeah.
They and so they either not kept current with their payments to SBA or whatever, and their loans are now being referred to Treasury for collection, and Treasury is being quite aggressive in their collection, their imposition of penalties and collection of those liabilities. So that's a space that our firm is very quickly and aggressively moving into, because we're seeing it all over the place. So I think if the listening base here is having people coming to them and they're like, my SBA loan's defaulting, I don't know what to do, that is definitely an area that we're moving into.
Give you guys a call. That's great. Yep. That's good to know. Yeah, because I know some of that's going on. So
there's
next big thing.
If I can just highlight.
Oh, sure.
Part of the tariff issue is what to do for folks who aren't the importers of record. Meaning, imagine a scenario where you buy a boat from overseas, and that importer is going to bring it through, going to pay that tariff and charge it immediately to the boat owner, and they go on their merry way. They have no motivation to go and seek any sort of refund because they've already been made whole. They don't want to hire an attorney. They don't want to go through the process for whatever this is going to be. And the question becomes, well, what is that person who purchased the boat supposed to do? And what is their relief? And the Court of International Trade has made itself, or made it known, that it believes that the ultimate payor of those tariffs has standing to sue. And that may be the situation where you can help a client if you know that they made some sort of a purchase like that. To Jessica's point, it's not every Costco customer who bought a tube of toothpaste, but in those situations where you're maybe you're a dealer of automobiles or motorcycles or something along those lines, where you can sort of trace it back. It's going to be a two-step process because the government's not going to pay you directly, but you may, through your own efforts and standing before the court, get that importer of record paid, in which case you need to go get those refunds from them if they're not going to turn them over.
Okay. All right. Another good piece of advice. Again, guys, thank you. I'm sure if I heard right, askfrost.com. That's how to find you guys. And again, thank you so much for doing this. I think this was a great hour, and I hope we do this again.
Thanks, Roger.
Thank you.
Thank you. And guys, thank you for listening. I hope you enjoyed today's Federal Tax Update podcast. If you did, tell some friends about it. And we'll be back in a couple of weeks with another Federal Tax Update podcast. Thank you.